Gelakasla, good morning, everyone, and I am really honored to be here and certainly want to acknowledge the territory of the Algonquin people. My name is Jody Wilson-Raybould. My traditional name is Puglas, and I come from the Muskama, Zawadanuk, and Likwikda people of Northern Vancouver Island. I would like to thank Michelle Hollis for the kind introduction. Sorry that I wasn't in the room when you made it. But I'm very appreciative of being introduced to such an esteemed group of people, and thank the Canadian Bar Association for the introduction. It's my pleasure to address a room of legal professionals in my still very new role as the minister. It was a great privilege for me to have been elected the Member of Parliament for Vancouver-Granville, a new riding just in the Vancouver area, and subsequently invited by the Prime Minister to be the Minister of Justice and the Attorney General of Canada. An appointment that speaks volumes about how far we've come as a country, and also about the important work that lies ahead. My appointment is not so much a reflection of myself personally, but rather the symbolism of which the appointment represents. That in a nation where an Indigenous person who not so long ago could not vote, let alone run for office, nor be recognized legally as an Indian and a lawyer, someone against whom the law discriminated, and to a certain degree still does, that someone who fought against those laws for years is now the principal lawyer in charge of administering that law on behalf of that very nation and advising its government. It takes a moment to sink in. I am now the steward of the Canadian justice system, and I take my responsibilities and accountabilities in this role very seriously. And while I can think of no greater honor, I am equally struck by the gravity of the responsibility entrusted to me, but also the opportunity. Opportunities that can only be realized with focus, hard work, and cooperation of others. I've come to appreciate that the Department of Justice is really the largest law firm in Canada. I have approximately 4,500 employees, of which 2,500 are lawyers. At this time, as a department, we are responsible for some 45,000 cases where Canada is a party. This also takes a moment to sink in. I've been an advocate for change nearly my entire life. My upbringing, my education, my professional and personal experience have all shaped my worldview and the way I work, as well as the approach that I take as minister. As someone who recognizes the importance of collaboration and consensus, I was pleased to see this year's theme of the Midwinter Conference, the power of unity. For me, the power of unity has special meaning in the context of the Indigenous political system in which I was raised, including the traditions of our big house. It is the big house where our laws are made and important decisions taken. Within Indigenous political systems, generally, there are no political parties. Rather, there is an idea of consensus. The issues are debated, and while not all may agree to every aspect, consensus is sought in order to achieve balance in society and to help ensure decisions that are made are durable and survive the test of time. So on this note, I might add that I do not think I will ever really get used to the etiquette in the House of Commons, and in particular during question period, where the power of unity is certainly not the order of the day, where in fact, in our often hyper-partisan politics, it is quite the opposite. That said, I truly believe the vast majority of people want to work together. There is no question that when people work together towards common purpose and with common vision, it is amazing what they can accomplish. The idea lies at the core of our Prime Minister's vision, and what we want to accomplish, as well as mine. We're Canadians, in the spirit of unity of purpose, embrace the incredible diversity that is Canada, making us stronger economically, but more importantly, socially, as a beacon of hope in an otherwise divided and troubled world. In Canada, the primary expression of our respect for diversity, our balance between individual and collective interests, and thus the unity that is Canada, is through our Charter of Rights and Freedoms. Essentially a place where all people can see their reflection, or ensuring a place where all people can see their reflection in our Constitution, knowing that if they work hard and abide by the rules of law, they will have the opportunity to succeed, always knowing that they are protected and supported through the institutions of the state. I believe passionately in the vision of an inclusive Canada, as I'm sure you all do, and I believe that our country can become even better, more just, more compassionate, and therefore more inclusive. Accordingly, part of what I want to talk about today is how we can accomplish this. That is by fundamentally embracing Canada's diversity in new and different ways. We can and will achieve improved outcomes for our nation. And in doing so, we strengthen ourselves, we strengthen our communities, and we strengthen Canada. We become more prosperous. As a government, we have begun to re-examine what we do, why we do it, and how we can measure success. We are identifying what is working, what is not working, and how we can best change it. Ultimately, this government aims to broaden the concept of success beyond economic wealth to include physical and social well-being, equality, and fairness. And in doing so, all Canadians must be able to share in this success. If a strong economy disproportionately only benefits some, you cannot say there is a just society. You also sow the seeds of discontent. A strong economy must always be seen as a means to an end and not the end in itself. The end is an improved quality of life for all. Now, in meeting our vision, I could begin by listing all of the priorities that I wish to address in my new role as minister, but I do not need to, because the priorities of our government have been already outlined and provided to the public through posting of ministers' letters from the Prime Minister. This is the first time in Canadian history that federal ministers' mandate letters have been made open to the public. This reflects how we want to approach our relationships with Canadians and with other levels of government by redefining open and transparent government. We believe it will lead to better collaboration, better government, and greater success for Canada and Canadians. To aid in this, we are investigating ways that my office can be more efficient and effective, as well as open and transparent. And to me, these two concepts are not separate and independent from one another. Rather, to the contrary, they are inseparable. In fact, it is evident to me that Canadians want to be more engaged in how their nation is governed and to have substantive policy discussions with decision makers on the very matters that affect them. I, in turn, believe the richness that can come from working with Canadians in ways to better informed cabinet is for the better. Contributing to these goals, the vision, is really what inspired me to run for office and then accept the Prime Minister's invitation to be in cabinet. This is what challenges and inspires me every day. It's actually what keeps me up at night. Key in my mandate letter, reflecting one, if not the primary role of the Minister of Justice and AG, is to ensure respect for the rule of law and to safeguard that the Charter of Rights and Freedoms is upheld. As Minister, I am guided by the Charter and effectively serve as its ambassador. To this end, and on the advice of my officials, I am investigating ways that we can be more open and transparent on the Charter of Rights and Freedoms that are affected by government action or legislation, and on government's assessment of the public interest in balancing all of the considerations that go into government. I believe that we need to trust Canadians, and that by engaging in more open debate, we will deliver better results while reinforcing Canada's trust in their government. My mandate letter also asks me, or tasks me, to review Canada's litigation strategy to ensure that government's litigation positions are consistent with the Charter, our commitments, and our values as Canadians. As part of this review, I have already either discontinued appeals or am reconsidering the Crown's position in many cases. Some examples of where we have already done and taken some action include cases related to the right to wear the niqab in citizenship ceremonies, the government's duty to provide health care to refugees, collective bargaining with public sector unions, and abandoning the appeal of the decision to grant Omar Khadr's bail. There are, of course, other ways that our justice system can change so that it can be better able to meet the needs and expectations of Canadians and implement the vision. For example, this includes supporting more inclusive and advanced democracy, where the institutions of government are balanced and power shared appropriately across Canada. This means rebalancing our federation to include not only the provinces and territories, but also to include Indigenous governments that make up Canada, to advance the concept of multi-level governance and cooperative federalism. We must also increase faith in our democracy by reforming the criminal justice system, also in my mandate letter. There can be little doubt that society has evolved significantly in recent decades. When we stop to consider some of the issues Canada is facing, we realize that these are significantly different from 5 or 10 years ago. As a result, addressing these issues effectively requires different approaches. One issue that has dominated headlines recently is our government's commitment to legalize and strictly regulate and restrict access to marijuana in a careful and orderly way. But what I find interesting about this issue is not only what we are doing, but how we are going to get there. This is also attracting attention. Like all complex issues, there are so many elements that need to be considered as we move forward. And the only way for us as a nation to come to understand and develop public policies on issues such as this is through meaningful engagement and openness with one another. For me, this means redefining how we work, or how I work with my colleagues, but it also means how we, in turn, work with Canadians so that our process is more inclusive. The issue of physician-assisted dying is another highly complex social and legal issue that must be addressed in a timely manner. Much has changed since the Sue Rodriguez case. The Supreme Court of Canada has spoken in Kay Carter and the Gloria Taylor case. And while there may never be full agreement on the issues involved, we must strive to try and achieve consensus on the proposition to be presented to Parliament. And while we did manage to get a 4-month extension from the court-imposed deadline, Canada must and is working diligently to have a solution by June the 6th. To this end, both the federal and provincial external panels of experts did a good job in gathering evidence and listening to the views of a broad range of Canadians and international experts. Now we have begun engaging Parliament to design an effective solution. Next week, the Special Committee on Physician-Assisted Dying, a parliamentary committee made up of members of Parliament and senators, has heard from 60 witnesses in the past number of weeks, will release their recommendations. There are so many questions that must be answered. What type of regime would best serve Canadians? What kind of partnership can be forged with the provinces and territories, as well as other stakeholders? How can the law address issues of access while protecting the conscious rights of medical practitioners? Again, clearly, the best way to answer these questions is through careful and open collaboration, by getting people with different views on the relevant issues to work through them together, by looking to those best placed to help us work through these issues, by transparently making relevant information readily available to Canadians and reporting on progress. We can create an environment that will position us to best achieve the best possible solution for Canada on this incredibly sensitive issue. So one area which is perhaps the most challenging but most necessary and long overdue is reconciliation with Indigenous peoples. Rebuilding the nation-to-nation relationship that lies at the heart of Canada, an issue I know intimately, and something I, along with all ministers, are tasked with addressing in our mandate letters. This is a priority of our government. We need to find long-term solutions as we collectively deconstruct the colonial legacy and develop in full partnership with Indigenous peoples a new framework and new mechanisms for reconciliation based on recognition. Many of the solutions that have been talked about for years, but what was missing was the political will and the direction to proceed. As we move to the 150th anniversary of Confederation and the 35th anniversary of the Charter, there can be no better way to celebrate the spirit of these important milestones than by charting a path for true reconciliation with Indigenous peoples in order to complete the unfinished business of Confederation. We can and will redefine the relationship in a fundamental way. For legal professionals working in this area, one of the biggest questions is how do we implement the United Nations Declaration on the Rights of Indigenous Peoples, and in particular, the concept of free, prior, and informed consent. On this multifaceted question, there are many views and a number of options. All require a new relationship. And it will need to be a made-in-Canada approach, reflective of our unique constitutional requirements and our evolving federalism as informed by the courts. This work will not be easy, but anything worthwhile rarely is. The work will need to survive the life of one government and will require a high degree of nonpartisan consensus. While my good friend and colleague Minister Bennett has the primary role to play in this work of reconciliation, in developing the mechanisms for the necessary transition, there is clearly an important role for my ministry. Currently, approximately over 10% of the more than 45,000 cases directly address Indigenous issues. These cases, in particular in relation to the environment and the economy, touch on all levels of government. They pose important questions about how we see ourselves as a society and as a constitutional democracy. The position the Crown takes in the court can and does have an impact on the pace at which reconciliation occurs. As part of my mandate to review the litigation strategy, I have instructed my officials to seek additional time on a number of key Indigenous cases in order that the Crown can reassess its position. Many of you will be familiar with the recent decision of the Canadian Human Rights Tribunal, which found underfunding in child welfare and that Canada is wanting in its support. There were some questions as to whether or not I would appeal that decision. I can say that I will not be seeking judicial review of this decision. This is part of the new relationship and necessary in terms of the spirit of reconciliation. While we cannot change history, we can address it, learn from it, move forward, and lay the foundation for a better future. We must ensure that Indigenous peoples are able to realize their full potential, to contribute fully to their communities, to the economy, and to society as a whole. For me, an important lens through which we can collectively understand this process of change and to support the transition is to honestly confront and fully resolve the ongoing tragedy of the murdered and missing Indigenous women and girls. The disappearance of these women and girls is an issue that we cannot ignore and we must take swift action to address. Many of the women are certainly victims of crime, but the issues extend well beyond our criminal justice system. Indigenous women have long been and remain one of the most vulnerable groups in society. And surely a critical measure of the prosperity is how a society treats its most vulnerable members. As you know, I am working alongside the Ministers of the Status of Women and Indigenous and Northern Affairs. And as a first step, our government has held pre-inquiry meetings across Canada with survivors, family members and loved ones of victims, as well as with representatives of provincial and territorial governments. The views gathered during these meetings will inform the design and scope of the inquiry, as well as the actions that follow. I see the inquiry as an important opportunity to make Canada more just and inclusive, to recognize and embrace the important place that Indigenous people occupy in our country and the hearts of Canadians. How we address Indigenous issues in this country, I know, will be the lasting legacy of our government. Finally, today I want to talk a bit about the criminal justice reform that we want to achieve. This is part of our overall re-examination that this government is embarking on, as I mentioned earlier. In undertaking this rethink, I recognize our approach must be both evidence and principle-based. And as we move forward, we need to ensure our positions are consistent with the Charter and with Canadian values. When we reflect in this context, it would seem that there are three areas that we should examine. The first is that our criminal justice system seems to impact the more vulnerable segments of our population more than others. For example, we know that our criminal justice system affects Indigenous peoples in a shockingly disproportionate way. They are far more likely than other Canadians to be arrested, prosecuted, and incarcerated. Last year, Indigenous peoples comprised more than 20% of the total federal offender population. And the number of Indigenous peoples behind bars has increased by 17% in the last 5 years. The story is all too familiar to me as a former Crown prosecutor. A young person, all too often an Indigenous male, commits a non-violent property crime, comes into contact with the justice system, and never really leaves. He gets caught in a vicious cycle of court appearances, court orders, breaches of court orders, and returned to custody. Soon the young person is spending more time behind bars than in his community and has little hope of breaking the cycle. And to be clear, understanding issues in our criminal justice system must not only focus on the treatment of Indigenous peoples. The truth is that many offenders have some combination of mental illness and addiction. Up to 80% of all federal offenders have past or current substance abuse issues. Some studies indicate that 2/3 of all crimes are committed while under the influence of drugs or alcohol. Imagine if we could change the system to better align it with the needs of all Canadians. What if an offender's first interaction with the criminal justice system did not become the first in a series? What if it triggered mechanisms designed to address the factors that inspired the criminal behavior in the first place? The second area to closely examine is what we need to rethink, what we define as a criminal offense while remaining vigilant to those offenses that are serious in nature to ensure that resources are dedicated to the right things. Currently, the system devotes most of its resources to administration of justice offenses, such as the failure to appear in court. These offenses comprise a large volume of cases in our adult criminal courts. In 2009, they accounted for 21% of all cases and cost taxpayers an estimated $729 million. And most involve chronic offenders, both Indigenous and non-Indigenous, caught up in the vicious cycle I described a moment ago. It will only be through careful examination and retrospection that we will be able to recalibrate the efforts and resources of the justice system on those crimes that are serious in nature. This is where we will have the biggest impact and produce the greatest results for Canadians. And the third and final area I would like to reflect on stems from the realization that the world is changing at such an incredibly rapid rate, and the criminal justice system must keep pace to remain relevant. In short, we need to have a criminal justice system that can deftly respond to the ever-changing environment. More and more new and emerging trends in the criminal justice system involve cyber-related crimes. Technology has created new opportunities for criminals, and statistics suggest that cybercrime is increasing in Canada. Between 2011 and 2013, the RCMP saw reported incidents of cybercrime increase by more than 40%. And incredibly, some 1.75 million Canadians reported that they had been cyber-bullied, but only 7% of victims had reported the incident to police. Issues like cybercrime and online privacy have never before been more prevalent. Our justice system must start to address these new issues and be able to react quickly to what our modern information age brings, while anticipating new and emerging issues, while remaining true to Canadian values. So before I close, let me say this. Our society, reflecting our values and constantly evolving, is underpinned by our justice system. The common and civil law reflect the values of society as it evolves, as guided by the laws made by the various levels of government. A living system of multi-level governance and cooperative federalism alongside an independent judiciary. I want to acknowledge the people who are at the core of our justice system. Legal professionals like yourself, law enforcement, and correctional officials. All of us have a role to play in helping make our justice system work, to make it better and to make it more responsive. And moving forward, while the stability of our justice system and consequently Canada's success absolutely depends on the involvement of individual legal professionals and groups such as the Canadian Bar Association, it also means including others in the conversation, perhaps those who have not been a part of the conversation before. As I have touched upon today, I am convinced that their involvement will lead to richer outcomes, outcomes informed by a diversity of perspectives. This is how we will find solutions, and this is how we will be assisted in building a stronger Canada. As I said, I'm truly honored to be the Minister of Justice and the Attorney General of Canada at this incredibly important period in our history, and to do my part to give back to Canada through public service. I would also like to acknowledge my parliamentary secretaries, Mr. Sean Casey and Mr. Bill Blair, in advance for all the work that we're going to do together. And finally, I am grateful for the work of thousands of public servants, the work that they do each and every day in a multitude of fields. But I would like to give particular thanks to those within the Department of Justice. Special acknowledgement to my Deputy Minister, Bill Pentney, who is here today. All of these public servants work to support me, but most importantly, work to support the justice system that protects our way of life. I have great aspirations for this country. I know that this country has not met its full potential and is very much a work in progress. But I am also seized with the urgency to act quickly and to deliver meaningful results for Canadians today. I welcome your engagement, and I look forward to working with you to meet the expectations of Canadians. Through the power of unity, we can all contribute to Canada's success. Gaila Kusla, thank you for allowing me to say a few words.
Thank you so much, Minister. That is somehow simultaneously sobering and encouraging, but certainly very informative. We know that you are extremely busy, and we can't say enough how pleased we are that you were able to join us. Thank you.